so that people can start to connect. But that's okay, just so you're aware. Hi everybody, thank you for joining us this morning. We're just going to wait another 30 seconds, 1 more minute or so until a few more people have connected. But yeah, thank you for joining us. Okay, great. Well, I'll begin now. So good morning, everybody. And on behalf of the Spanish Chamber of Commerce in the UK, thank you very much for joining us for this morning's virtual panel discussion, which is on the topic of British law, your key questions answered. We're delighted to be holding this event in collaboration with our member, the British Spanish Law Association, which is an organisation founded in 2001 to promote and strengthen relations between lawyers in the UK and Spain, drawing members from both jurisdictions. The aim of this morning's session is to provide you with a one-stop survival guide to family, succession, immigration and criminal law in England and Wales, with our 4 panellists aiming to answer all of your questions and to clear up any doubts that you might have. So I'm now going to introduce to you the 4 panellists that we have with us today that you can see on your screen right now. So the first is Alvaro Aznar Azcarete, who is an associate of the International Private Wealth and Tax Team and head of the Spanish desk at Child & Charles. He is a duly qualified English solicitor and Spanish abogado. He is the chairman of the British Spanish Law Association and is a trusts and estates practitioner. He possesses strong professional skills in cross-border matters, legal assistant, private clients, high net worth individuals and estate law. We also have with us Paula Piqueros, who is a senior solicitor and Spanish lawyer at Buckle Solicitors in their family department. She is a qualified Spanish abogado and English solicitor. She's a member of the Barcelona Bar and its Family and International Law Commissions, the Spanish Association of Family Lawyers, and is also the deputy chair of the BSLA. Paula also frequently lectures on English and Spanish law and cross-border matters at seminars and conferences. We next have with us Sophie Barrett-Brown, who is a senior partner and the head of the UK practice at Laura Devine Solicitors. Sophie has an extensive experience in all aspects of UK business immigration and nationality law and EU free movement, and her clients are drawn from all sectors and range from multinational corporations to entrepreneurs, high net worth individuals and families. She is also a prolific speaker and commentator on immigration topics and is widely regarded for her policy work. And finally with us today, we also have Richard Saynor, who is a barrister at 23 ES Chambers and a highly regarded and sought after practitioner with a busy advisory and court practice. His practice encourages both criminal and civil law, with an emphasis on financial crime and asset forfeiture and recovery. Much of Richard's work involves an international element, and he routinely acts for those who operate and live in foreign jurisdictions, including advising on issues such as mutual legal assistance. Richard is also the secretary of the BSLA. I'd like to remind you all that we want this to be an interactive session this morning, so please do write in with any comments or questions that you have. You can do that using the tools that you see at the bottom of your screen in Zoom. So there's the chat function where you can write to the panelists directly or to myself too, or the Q&A function as well. We're going to have plenty of time at the end for your questions to be answered by each of the 4 speakers, who are each going to now speak in turn about their area. So thank you very much, and without further ado, I'll now hand over to you, Alvaro.
Thank you, Hannah. Well, good morning, everyone. Thank you very much for joining. I'm going to speak about state administration in England and Wales. Basically, the process is totally different to those in many continental jurisdictions. So forget what you know, how it happens, for example, in jurisdictions like Spain or France, because here is totally different. So instead of speaking about the entire process, what I thought it may be more useful is that I explain you concepts that you may have heard of or you don't know about. So in states, I think the first stop will be speaking about wills. Well, wills are necessary. I mean, you are never too young or too old to have a will. Here in England, contrary to what happens in Spain, the will is drafted by your solicitor in accordance with your instructions. You will sign it in the presence of 2 independent witnesses, and you will appoint executors. And for example, if you have minors, guardians for your children, you can have provisions for disabled beneficiaries to protect their interest. And also, if you are living with an unmarried partner, you can leave assets or in your will to your unmarried partner, because otherwise they will not be entitled to automatically to your estate under English law. So basically, one of the important aspects of the wills here is that your solicitor will obviously, take your instructions, advise you as to regarding tax matters. And one of the things that we mentioned earlier is the executors, that they are very important in your will. I will explain their role more carefully later on. So another concept that is very important is the concept of the estate. Basically, many of you may have heard the estate of someone. The estate are the assets and liabilities of the deceased. So you can have there are 2 types of estate. There is the gross estate, which is before the payment of the liabilities. And then you have the net estate. So the net estate is what is left after the payment of the liabilities, taxes, and so on. Another concept that is very interesting and dreaded by many people is inheritance tax. No one likes to pay inheritance tax. So basically, one of the main differences in inheritance tax in the UK is that, contrary to what happens in many continental systems, like for example Spain, the inheritance tax is not paid by the beneficiary, it's paid by the state. So basically, in the UK, everybody has what is called a nil rate band. There is a nil rate band of 325,000. This means that the value of the estate under 325,000 will be exempt of inheritance tax. Any amounts exceeding 325,000 will be taxed at 40%. Now, that doesn't mean that all the estates pay inheritance tax. If you're, for example, if you are married, you can have what is called the spousal exemption. So basically, assets passing between spouses will be free of tax. Now, this is very frequent for inheritance tax, for estate planning, that most of the estates are here in England, contrary to what happens in Spain, is that everything passes to the surviving spouse, and on the second death to the children or to other beneficiaries. Why it is that? Well, it is because of something that is called transferable nil rate band. So basically what happens is that we were talking about spousal exemption and nil rate band allowance. So for example, if you leave everything to your spouse, you haven't used your nil rate band allowance of 325,000. So when the second spouse dies, they can accumulate, the state will accumulate your 325,000 plus the 325,000 for your spouse. So then you will have a nil rate band allowance of 650, which can be a considerable saving when it comes to inheritance tax. In addition, there is something called main residence nil rate band. This can apply on there are certain criteria, and unfortunately I don't have the time to go into this more in detail, but in my handout that will be sent after the webinar, you will have more information about this. For example, if there is the main residence of the deceased is part of the state, and for example, this person is married, they can accumulate between the spouses the main residence nil rate band, subject to a certain number of criteria, and that the property goes to the descendant. So in addition, there can be a combined nil rate band allowance of 350. So that brings us up to 1 million in potential exemptions or in terms of inheritance tax, which again can be quite a saving. Something that is very important as well are the gifts. Now, if you are a Spanish national or a French national, you may be aware that when you gift something to someone, you will trigger automatically gift tax, especially in Spain. Here in England is different. So for example, you can give something to someone And if you survive 7 years, this is what they are called the potentially exempt transfers, there will be no inheritance tax. Now, that doesn't mean you can gift anything. For example, imagine that your parents say, well, we gift you our house because we don't want you to pay inheritance tax. Now, that will be a gift with reservation, because basically your parents, although they're gifting you the house, they're still living on it and benefiting from their use. So basically, in that case scenario, that this rule will not apply. So the property will fall under the inheritance tax remit. So it's you have to be very careful when you gift something to someone, because you are gifting it. You are renouncing to all your to all your rights over that asset. One other topic that I think is very important in states is the concept of domicile. Many of you, I'm sure you have heard the concept of he's a non-dom or she's a non-dom. Well, basically, the concept of domicile under English law is that the place where a person belongs, the intention of an individual to belong to a place. Now, this cannot be mistaken by habitual residence, domicilio, or similar concepts. Basically, it is more complex than that. Now, under English law, everybody has a domicile. When you are born, you have one. If you are born to married parents and your father is alive when you are born, you acquire that of your father. Now, if your parents are not married or your father is dead when you are born, you acquire that of your mother. So when you are a minor, you have a domicile of dependency. So until you don't attain the full age, you will have the domicile of the person you depend on. Then this domicile can evolution to what is called a domicile of choice. So for example, you live in another country, but in order to acquire a domicile of choice, you need to sever or cut your ties with the jurisdiction where you had your domicile of origin. It's not just, for example, I spent 6 months in Spain, 6 months in England, I don't know where I'm domiciled. It requires a more in-depth analysis. Now, why domicile is important in states? Well, it is important for two main reasons. One of them is it will determine whether your state will be liable for UK inheritance tax. What I mean is your whole estate. And secondly, if it will apply, because it will apply to your movable assets if English law applies to your estate. So it is really, really important because the tax consequences can be quite considerable. In 2017, a new concept of domicile was incorporated, which was the concept of deemed domicile. Now, deemed domicile only refers to inheritance tax. So what happens is that you can, if you continuously live for example, in the UK for a certain period of time, you can attract a UK domicile, but this will be only for inheritance tax purposes. So this can be quite considerable because if you have assets in other jurisdictions or your beneficiaries are resident in another jurisdiction, like for example, Spain, you have to be careful because there is no double tax treaty for inheritance tax purposes in Spain, between Spain and the UK, and you will have to apply unilateral tax reliefs. And that's something that you will need legal advice to do that. Another concept that is very important in states is the concept of personal representatives. You may not have heard the term personal representative, but I'm sure you have heard the term executor, administrator. Well, the personal representative plays a key role in the state. Forget about the beneficiaries. Beneficiaries play a very, very minor role, contrary to, for example, what happens in Spain, that the beneficiary takes control of the state. Here is the personal representative. You have mainly two types, which are the executor. The executor is always appointed in a will, and the administrator, that is when there is no either no will or no mention of an executor appointment in a will. Basically, there is not much of a difference between them, but the main difference is that the executor can start acting for you or for the state once the testator is dead, but the administrator will need a court order to act. So for example, if there is a potential contentious matter, like for example, there are occupiers, illegal occupiers occupying the property of the deceased, and there is no will, you cannot do anything until there is a grant of representation in favor of an administrator, and that can cause delays. So for example, what can happen if you have a Spanish will and you have assets here in the UK? Well, basically, in 99% of the chances, there will be no executor appointed in a Spanish will because we don't have them in Spain. And basically what will happen is that when you die, there will have to be an appointment of an administrator. Now, the problem is that not everybody can be an administrator of an estate. There is an order of priority that is set in the non-contentious probate rules as to who can take the grant. Now, you can be in a situation where the not the most suitable individual will be taking such important task of administering your estate. So my advice is, if you have English land, to have an English will appointing executors. And again, it's really, really important that you appoint the correct executor. Now, another concept will be the grant of representation. So the grant of representation, you can call it, there are various types. I'm sure many of you may have heard of the grant of probate. This is when an executor is appointed. There is the letters of administration or the letters of administration with annex will, which basically, these ones is, for example, if you have a Spanish will where there is no executors appointed, you will be obtaining, or your beneficiaries will be applying for the letters of administration with will annexed. Another concept that is very interesting under English law is the concept of intestacy. What happens if you don't have a will? So I don't know if many of you have wondered what happens if English law applies to your estate and you have no will in place. So basically what happens is that there are some provisions. So the most common one, for example, is if you are married and you have children. So what happens is that on your death, the first £270,000 will pass automatically to your spouse, together with all your personal possessions. And the remainder of the estate will be divided in two. So one half will be an absolute interest for your surviving spouse, and the other half for your children. Now, earlier we talked about spousal exemption. Basically, if you die intestate and your assets are distributed as I just mentioned, your estate may not be very tax efficient, because not everything will be passing to your surviving spouse, and inheritance tax will be due. So another concept that has been a favorite of mine for a while, and is complex, is the European Succession Regulation. I remember seeing in the Spanish press years ago articles stating that there is a new European regulation that will help Spanish nationals bypass the reserved heirship rules that we have for children and for our descendants and ascendants. Well, basically, the European Succession Regulation that came into force in 2015, the UK is not a party to this regulation. However, it still affects UK nationals that have property in a regulation member state, which broadly is most of continental Europe, or member state nationals of this regulation that live, for example, in the UK. So, for example, if you're a Spanish national and you live in the UK and you have not made a will, if you have habitual residence here, English law will apply by default to your estate. Now, what happens is, because you have not made a choice, an active choice to English law to apply, because don't forget, that you cannot make a choice to English law unless you are a national of the UK. So what will happen is that, okay, you die, habitually resident in the UK, and what will happen is that your movable assets will be dealt under the laws of your domicile. So if you have retained a domicile of origin in Spain because you want to go back to Spain and you have not severed your ties to Spain, your movable assets, in theory, will be dealt under Spanish law. And the immovables, where they are located. So for example, if you have assets located in London or in England under English law, if you have assets in Spain, in Spain. Now, the problem with this regulation is that in Spain, for example, it is not applied very consistently in terms of this renvoi to other laws. So my advice is, if you have assets in, for example, in another jurisdiction as well, to carefully plan and have the correct wills in place, and always seek advice from lawyers in both jurisdictions, and that they coordinate the advice amongst them. Because otherwise, what you can have is the perfect recipe for an international disaster. And I've dealt with various estates that the testator had the brilliant idea of having wills made by W.H. Smith or themselves, and assets in Spain, and it was, some of these estates can take up to 5 years to sort out. And imagine the legal fees that this can trigger, basically. So I don't know if I have time, but just very briefly, I wanted to touch on something that I think is very interesting here in England. It doesn't have to deal with succession. Not everything is bad news. So is the lasting powers of attorney. I don't know if any of you have heard of them, but the lasting powers of attorney are an instrument that are very useful when you no longer can act. So for example, if you have lost capacity or you are convalescent. So basically there are two types. There is for finance and welfare. Very briefly, the one for finance basically deals with all your financial aspects. For example, your pension, payments of bills, bank accounts, sell your property. Or welfare, that deals with, for example, medical decisions, whether you want to be in a care home, treatments, etc. The LPAs, once you sign them, you have to appoint, obviously, attorneys that they will have to accept. They will have to sign the documents as well. So the good thing is that these documents are registered with the Office of the Public Guardian, and the attorneys can act immediately once the document is registered. However, if you still have capacity, they will have to act with your consent. However, it's good because, for example, if you have lost capacity, they will be able to ensure that all your finances are being dealt with. A Spanish power of attorney will not be accepted here. I mean, I had lots of matters where Spanish powers of attorney had been sent here to deal with the finances of relatives of clients of mine, and the banks normally do not accept them. So it is very important that if you can, the LPA, I mean, they're straightforward. However, I would advise that you seek legal advice to have the document ready. They're not very costly, because if you lose capacity, the only resort available will be that the people close to you apply for a deputyship order, that this can be a lengthy and very costly exercise. So, well, this is all for me. I leave it to Paula, and thank you very much. And if you have any questions, please ask me later. Thank you.
Thank you, Alvaro. Good morning, everyone. Thank you for joining us. So my colleague Alvaro spoke about the most frequent reason for the breakdown of a marriage, which is death. I'm going to be talking about the second most common reason for a marriage to break down, which is divorce. The intention today is to give you an overview of how English family law works, but obviously family law is much more extended. So divorce, well, bear in mind that regardless of where your marriage took place, what is your nationality, if you are both living in the UK, English courts are going to have jurisdiction or are going to be competent to deal with your divorce. And therefore, it's important for you to know how English law works, because essentially English law will be applicable to your divorce. So under English law, when you want to start proceedings, you must have been married for at least 1 year. And I'm pointing this out because in other jurisdictions, such as Spain, you only need 3 months to have elapsed from the date of marriage to be able to file for divorce. It's not the case in the UK. You must have been married for at least 1 year. Unfortunately, at today's date, we still have grounds for divorce under English law. What does it mean? It means that when you apply for divorce, you need to prove that the marriage has broken down, and you need to put forward to the court one of the 5 reasons why that marriage has broken down. These are basically adultery, unreasonable behavior, desertion, 2 years separation with consent by the other spouse, and 5 years separation without the need of consent from the other side. The most commonly ground used is unreasonable behavior. Why? Because otherwise you need to wait 2 years from the moment of separation to be able to file, and you will still need your spouse's consent for the application to go ahead. The downside is that when you use unreasonable behavior, you need to give reasons that the other party's behavior has made you decide to terminate with that marriage. And that doesn't always go very well, because the reasons you need to give need to be reasonable and need to be strong enough for the judge to consider that, yes, is enough for you to want to break down your marriage. Together with divorce, we have the aspect of your financial assets. What happens with your assets when you decide to go ahead and break down your marriage? Well, I'm not sure if you are familiar with the concept of matrimonial property regimes, but this is something that is very common in continental Europe. Just so you have an idea, matrimonial property regimes is basically a set of rules that regulate the financial dealings during the marriage, within the financial relationship with your spouse, but as well establishes the rules of what is going to happen at the time of divorce. Therefore, in some way, there is certain certainty as to what is going to happen in the event of divorce. Well, under English law, forget about that. We don't have matrimonial property regimes. They don't exist. And what happens is that during the marriage, each spouse retains their assets. You can acquire property jointly in separate names, however you want. And it's at the time of the divorce when the assets are going to be distributed in accordance with the judge's discretion. This obviously leaves a lot of uncertainty to the parties, and especially if you come from a continental jurisdiction where you have certain security as to the fact that your assets are going to be protected. So what is the default position or the starting point under English law for the division of assets? Well, this will be split 50-50 among the spouses, all the matrimonial assets. What are the matrimonial assets? Well, these are assets that have been generated during the marriage, regardless of who has ownership of those assets. Okay, so for example, if you have signed a marriage contract in France, Germany, Spain, choosing a separation of assets regime, once you move to the UK, you need to bear in mind that this marriage contract is unlikely to be respected by the English courts. What you need to bear in mind is also the powers that English courts have in relation to the orders that they can make. It's important for you to know that they can make orders for sale. This means that they can force that the matrimonial home or a certain property is sold and the proceeds are divided between the parties. The percentage might be 50-50, might be 60-40, depending on the circumstances of the parties. Also, they can make orders for transfer of property. This means that an asset that is solely owned by you, usually the family home, can be transferred to the other spouse. If, for example, you have more capacity to generate more income, to get another mortgage, and the other spouse has no financial resources, this is something that the judge can order. They can also order lump sum payments, which is basically you will need to pay this person X amount for them to be able to either buy a property or make some investments to generate income, etc. There is also spousal maintenance, which is periodical payments to help the spouse get some sort of help that they might need as a result of the marriage, of the breakdown of the marriage. And pension share. This is important because this is something that under Spanish law, for example, we don't have, but under English law, the judge can order that a percentage of your pension is, at the time of your retirement, is distributed to your spouse. What else is important to bear in mind? We touch on the subject that matrimonial property regimes are non-existent, and that therefore marriage contracts are unlikely to be upheld by the English court. What is a way around this? Well, if you are planning on relocating to the UK, or you have already done so, you might consider wanting to sign a postnuptial agreement. At today's date, you need to bear in mind that neither prenuptial agreements, which means agreements that you enter into before the marriage, nor postnuptial agreements are absolutely enforceable under English law. But it's definitely, if you comply with certain safeguards, is something that the court is definitely going to take into consideration and is going to follow what the parties have agreed, as long as it's considered fair. As part of the process, how the court is able to decide on what is fair, how they should distribute the assets, the parties must provide full and frank disclosure of all their assets, no matter where they are located. So this includes all your worldwide assets. This is done in a very lengthy document. It's around 25 pages long, and you need to provide all sort of evidence in terms of your income, bank statements, pension arrangements, any private investments, everything. What happens when the parties are not married? Well, forget about everything that I have explained, because none of it will apply. Under English law at present, we don't have any sort of protection or regulation for couples that are not married but are living together or have kids together. Therefore, that means that there cannot be any financial claims between the parties as a result of the breakdown of their relationship. The only exception is that a party might have a claim against the other person when, for example, they own a property that is solely owned by one of the parties, and the other side has made significant contributions to the mortgage payments or any renovation works. Then you might have a claim against that property. And when you have children, you might also make claims to ensure you have enough provision for the children. This can be either for periodical payments or even the transfer of a property in your name for the benefit of the children. Even though there is no regulation for cohabiting couples, and even though that at present they have no claims or rights or obligations towards each other, it's always advisable to enter into what is known as a cohabitation agreement. It's not necessarily enforceable, but it's something that the parties can establish how their financial dealings are going to be during the marriage, during the relationship, and what will happen once the parties have separated. Another way to have some certainty is if you're buying a property together, it's always advisable to do a declaration of trust, in which basically you are going to be declaring who owns what percentages over the property. And if, for example, one has made a larger payment for the deposit, that can be recognized. So in the event of a separation and the house needs to be sold, it's quite clear who is going to receive what and who is entitled to what. So what happens with children? Well, bear in mind that the same rights and obligations apply to parents regardless of whether they're married or unmarried. The only requirement is that both parents are registered in the child's birth certificate, which is the one that gives you, which entitles you to have rights and obligations towards that child. The English courts are going to have power to make decisions in relation to your children, regardless of whether they have been born, regardless of their nationality, as long as they have their habitually residence in England and Wales. So if they are living in England and Wales, English courts have the power to make decisions. What does this mean for international couples? Well, if you come from another country, decide to relocate after 2 or 3 years, the relationship breaks down, and one of the parties says, well, the only reason I came here is because my partner's job or my job, but now I don't have my family here, I want to move back to my country of origin. Well, unless you have the permission or agreement of your partner or the father, you are not going to be able to do that. If you do so, if you don't have the agreement and you still relocate with the children to another country, you will be committing child abduction. And this can have criminal consequences. But not only that, the fact is that there is international legislation that will, if it works in accordance to what the law says, it will force you return the kids to the country where they were living, and then have that court made a decision. So what do you need to do if you want to relocate with your children? You need to apply to the court and ask for permission of the court to allow you to relocate with the kids. So that's it for me. I hope you found this useful, and I will be glad to answer any questions you have later on. And I will now pass you to my colleague, Sophie.
Thank you so much, Paul. That was really interesting. And it falls to me to talk about the immigration side of things and the position of EU nationals in the UK. And I really want to cover this looking at different time periods, which I think may be the most helpful way to analyse it for those EU nationals and their family members who are already in the UK at the moment, for those who are going to be coming to the UK by the end of the year, and then what happens next year from the 1st of January. So those three distinct groups. I'm sure everyone here is aware that we have, sadly, in the UK left the European Union already, but EU free movement in fact continues. And whilst many people are still aware of that, we find that many clients are not fully familiar with that. I think there's still a lot of confusing messaging that's been put out by the UK government and different organisations. So if you're an EU national in the UK, as I think most of our audience is going to be in that situation, what's your position and what do you need to do? And if you have family members or colleagues joining, what will their position be? Well, as I say, EU free movement in fact continues at the moment. If you are already in the UK, you continue to have your EU free movement rights to reside here. And indeed, anyone who's an EU national or family member of an EU national who arrives in the UK by the 31st of December of this year will equally have those free movement rights. And the UK government has put in mechanisms to seek to preserve those rights after that date in UK domestic law rather than in EU law as they exist now. So I'm sure that many people will be aware that at the moment, under the sort of old provisions of how the UK is transposed to EU law, an EU national family member can apply for a document confirming that they have a right of residence in the UK. And once they have completed, in most cases it will be 5 years of residing in the UK, they can apply for a document confirming that they've acquired permanent resident status in the UK. That is all being replaced with an architecture of new approvals under UK domestic law, which is referred to as the EU settlement scheme. And I'm sure many members of the audience today will have already applied under that scheme. So if applying under that scheme, what do you get? Well, you get something called settled status. It's technically indefinite leave to remain, where the applicant has already resided continuously for 5 years in the UK. Where the applicant has resided for less than 5 years, it's something that's being termed pre-settled status, which is basically temporary leave to remain in the UK, to allow the person to complete a 5-year period and go on to get settled status. Now, some important considerations when applying under this. Number one, the deadline for applying is actually not until the end of June 2021, so one doesn't have to apply immediately, and in some cases people may opt not to apply. I'll come back to that point later. One of the really important factors to understand is that in order to qualify for settled status on the positive side, it's not, as EU law does, analysing have you exercised a treaty right in line with EU law. So this is things like working, being self-employed, being a student, being self-sufficient in the UK, and in particular in relation to self-sufficiency and being a student, one had to demonstrate under EU law that you had comprehensive sickness insurance in place for the whole of the 5-year period. The EU settlement scheme is not interested in analysing the detail of what the person has been doing in the UK for the last 5 years. It's really just has the person physically been here for 5 years. So it is much more straightforward than the applications that some of you may have made in the past or be aware of for documents confirming permanent residence and so on. So upside, nice and easy. There's the process of applying is actually very straightforward through an app in most cases, not in every case. But certainly compared to anything else we've ever seen in UK immigration law, it's much, much more straightforward. I think the key potential problem that we tend to see is to do with absences. So one doesn't qualify for settled status if you have had absences from the UK during that 5-year period of more than 6 months in any 12-month period, with some limited exceptions, the main one being a single absence of up to 12 months for an important reason. And there could be lots of things that may constitute an important reason. But for some people, it will mean that they have not actually completed a historic 5-year period, and they'll need to go on to complete that continuous 5-year period, having acquired pre-settled status. For those in that position who simply haven't been here for 5 years yet and they're getting pre-settled status, it's something you need to very much bear in mind in your planning, because it's a pre-settled status is a one-shot deal. You get given the 5-year period, but at the end of the 5 years, you either need to meet the requirement for full settled status, which includes falling within those limits on absences, or you don't get to proceed through that route. You can't extend it at the end of the 5-year period. So watching what's happening with absences is a really important factor. And what you can do is apply in another immigration category as non-EU nationals can, but for most people, of course, they'll want to avoid that and get the full benefit of settled status. One of the other aspects to flag is in relation to British nationality law. So some individuals may qualify to apply to naturalise or register as British citizens. Now, if someone is going to be eligible to naturalise and become a British citizen before the end of June 2021, they don't need to apply under the EU settlement scheme, because once you have British citizenship, it doesn't matter about the status, sort of preserving your EU law rights. However, in order to apply to naturalise, an applicant, when you're dealing with an adult applicant, must demonstrate that they have what we call no time limit on their stay. And so that's either permanent residence under EU law or indefinite leave to remain under the settled status scheme. One must have evidence of having that status. So either having a PR document that was issued under the sort of old regulations or a settled status approval. Now, the key distinction that impacts timing there is that a document recognising permanent residence is based on when was that permanent residence acquired, and EU law sort of happens in the ether. If the facts are met, you acquire the status. The document just confirms that you've acquired it. So somebody may have acquired permanent residence 10 years ago. They could apply now for a document that confirms that they acquired their permanent status 10 years ago. At least 12 months ago is the important factor. Whereas when applying under the settled status scheme, settled status, indefinite leave, is acquired at the point that it is actually granted. And for most applicants, you need to hold that permanent status or indefinite leave to remain for at least 12 months before applying to naturalise. So some people will still want to apply under the old permanent resident card route rather than under the USS if going on to apply for British citizenship. So that's factors to bear in mind. For many people, of course, a really important factor is going to be whether or not you can hold dual nationality. And there are restrictions around Spanish nationals holding dual nationality. Now, I'm not a Spanish nationality specialist, I'm a UK law specialist. I understand that the general position is, in most cases, that dual nationality is not permitted, but there are mechanisms to retain your Spanish nationality. I believe it's within 3 years of acquiring your other nationality. But that's certainly something to get advice on. For many other EU countries, they freely allow dual nationality as the UK does. And there are also issues around children. Many children who are born in the UK may already be British, and sometimes the parents will not appreciate it if the child has been born after the parent acquired permanent residence. And as I say, many people don't realise they've actually technically acquired permanent residence, and that child would actually be British already. If the child was born after, was born before the parent acquired permanent residence or settled status, then the child's entitled to register as British if they were born in the UK. So, that's just a very quick overview of the position for EU nationals seeking to protect their status in the UK for the future. As I say, those who haven't yet arrived but will be arriving by the end of this year benefit from the same arrangements. But those coming from the 1st of January 2021 will not benefit from those arrangements, with some limited exceptions of family members of people who have already met the requirements of the scheme. So what's going to happen from next year? We are due to have a new immigration system, and despite the difficulties and the fact that coronavirus seems to have taken over the world and everything that the government is doing, it still intends to plough ahead with ending free movement at the end of this year and bringing in its new immigration system. So a lot of you will have seen coverage about this in the press earlier in the year. The government proposes to introduce a new, it keeps saying, Australian-style points-based system. It is, in fact, absolutely nothing like the Australian points-based system. And in fact, it's very similar to our existing system. So probably the key areas in relation to workers in the UK, we have a system called Tier 2 for non-EU workers coming into the UK. That will now be part of a new points-based system. It may well lose its name of Tier 2, but many of the criteria are fundamentally the same, actually with a number of aspects being reduced. So for example, the skills criteria is in fact being reduced. There's presently a requirement to carry out what's called a resident labour market test. That's going to be removed, but in many ways it's very similar to the current system. So what we'll see from next year is that many EU nationals will actually have to fall within our standard UK immigration system that applies to everybody internationally. And there will similarly be a continuation of routes that exist now for family members, spouses, partners of British citizens, or people who already have settled status, and EU nationals will be able to apply to that if they meet the criteria in the same way as any non-EU national, if they don't benefit from the settled status scheme. So I want to sort of bring things to a close to allow enough time for other speakers, but just a really quick comment on the current circumstances in relation to COVID-19. It's been a huge issue for immigration, for EU nationals and non-EU nationals, and one of the obvious factors is simply the restrictions on the ability to travel, but it's restricted people's ability to make applications. And so in the UK, most applications that one makes involve attending a biometric centre and giving biometrics, and those centres have all been closed for many, many weeks now. But the green shoots are opening up this week in immigration, as they are in many other areas, and application centres are now opening in the UK and around the world, enabling applications to now proceed and be made. Some of you may have been trying to make applications under the EU settlement scheme. Most applicants have still been able to apply throughout this period, but certain applicants who were required to give a biometric had been effectively blocked from being able to apply. And again, those applications can now be made. So things are certainly improving and moving on as far as that aspect is concerned. And then I'll be happy to pick up on specific themes that we may want to dive a little more deeply into in the question and answer session. And for now, I hand over to Richard.
Hi there. I deal with the situation when foreign nationals in the UK are arrested and subject to criminal investigation, and what the position is, of course, if that occurs. I can't deal and don't intend to deal with the whole system, but what I do intend to do is deal with some of the flashpoints and really the key differences and areas where foreign nationals can be assisted by effective representation. So, of course, there is an incident that occurs that may constitute a crime that is either reported or discovered by the police. Police will begin an investigation. And of course, at the investigation stage, sometimes that can be very brief. Sometimes if one is talking about foreign companies, that can be incredibly long periods of time. It's not unknown in the UK for large companies who are being investigated by bodies such as the police or the Serious Fraud Office to be subject to investigation for years rather than months. And of course, all that time, they can be represented by lawyers who are assisting them in advising them on the process of investigation. And of course, part of the investigation is the interview process and the fact that the police can either effect an arrest, either in the street or the individuals can be invited for interview at the police station. Now, if you are a foreign national and you attend a police station, either because you've been arrested by the police or you voluntarily attended, then at that stage, you have the right for the embassy to be informed that you are being held by the police pending the interview. And of course, that's an important right because it lets the embassy know where you are. And of course, following on from that, your representatives can be contacted and it can ensure that you have effective representation at the police station, which is key if, of course, you're going to preserve your rights at the police station. Following on from that, of course, there is a consideration by the prosecution body, that is the CPS, or indeed there are many other prosecution bodies in the UK. And of course, this is another point at which effective representation can allow input into, at that stage, whether or not the authorities are going to prosecute either the company or the individual. And it can be the case that effective input at that point in time can prevent matters from progressing any further. I had a very recent case with two Spanish nationals who were arrested in the UK for sexual offences. And during the course of the investigation and the consideration for charge, representations that went in to the CPS and the police at that point about, in that instance, speaking to other individuals who were in the Airbnb where this is alleged to have taken place and carrying on the investigation to others who happened to be in the hostel that evening, led to all charges being dropped and the investigation ceasing after they considered the input of other individuals and thought they no longer had a reasonable prospect of conviction. The other key flashpoint, if the prosecution body has then decided to charge, comes the question of bail and what happens to a foreign national who's detained in the UK pending any trial. It can be the case that the police or court admits the individual to bail, or it can be the case, more worryingly perhaps for foreign nationals, when they are detained in the United Kingdom in prison pending their trial, remanded in custody effectively. And it's not uncommon for that to occur. In fact, statistics vary, but you are something between 60 to 80% more likely to be detained in prison pending a trial if you happen to be a foreign national temporarily in the United Kingdom. So in this situation, I'm speaking more of those perhaps who are on holiday here than work here on a long-term basis. But nonetheless, those who are foreign nationals in the United Kingdom, I think it's actually the same in many other European member states as well, in reverse. The position is that you are far less likely to be granted bail, and far more likely, therefore, to be remanded in prison pending any trial. Of course, this is where firms, both in the UK and in Spain, working in collaboration, can assist those individuals who are in that position. Because it can be the case that those individuals obtain bail in the United Kingdom. Say, for instance, the holidaymaker we were talking about, they through the assistance of both firms, secure a residence that then means they're able to remain in the community in the United Kingdom pending their trial. That's quite an expensive and unviable option for many, because of course the position is that you wouldn't be able to work, you'd be effectively waiting for your trial. Trials in the UK at the moment are well, before even perhaps the current pandemic, they were lengthy processes. Wouldn't be uncommon to wait for 8 to 12 months for a trial to take place in the Crown Court. And now, who knows, because latest figures are that they're adjourning 1,000 trials a month at the moment. So of course there is an enormous backlog. A far more viable option for many, therefore, is actually to be bailed back to Spain and or whichever European country that the person from member state came from, pending their trial. There is unfortunately a little known, used but very effective provision that allows for individuals who are foreign national detained in the United Kingdom, community members, to back pending this is monitoring any bail conditions whilst they happen to be back in Spain. The measure by which the courts would allow this is called the European Supervision Order. I say it's rarely used, but it is very effective when it has been used. And in fact, it has mostly been used in the United Kingdom in relation to Spanish nationals who have been returned back to Spain. So although it applies to all the member states that have signed up to this provision, a great many now, it's actually Spanish nationals who are most frequently bailed back to Spain. So it is a key provision. And the importance of firms working collaboratively is that the UK court would grant an order. It would then be sent to the Spanish courts, who would impose the order in effect in whichever local area it happened to take place, and notify the local police. In both those instances, I personally have found best, and certainly from speaking to other colleagues who've been engaged in the same process, when you have the representative firm in the United Kingdom speaking to the firm in Spain and ensuring at both ends that the procedure is going through court. That is by far and away the most effective process, and one whereby firms can assist those who they are both representing. You then move on from the trial to, if of course they are acquitted, then that's it, the case ends. If they are convicted, then you have sentence. Now, the key thing here to be aware of in relation to foreign nationals, many people often ask, either because they do or don't want to potentially, but will they serve their sentence in the United Kingdom, or will they be deported back to Spain if, for instance, they are receiving a custodial sentence? Will they serve the term in Spain, or will they serve the term in the United Kingdom? And actually, I've had clients who've wanted either. Some who have been in the United Kingdom for a year or so, came over to work, who want to remain in the United Kingdom, and some who desperately want to go back to Spain so they can be near to family and family can visit them. The decision, of course, whether or not they're deported is not one that actually the court makes in the first instance, and neither can it be something that's dealt with during the sentence process. But the Home Office can firstly trigger the deportation if even for a member from a European state, if the position is that they deem it depends on how long the individual has been in the United Kingdom and also the severity of the crime. If they deem that the crime to be sufficiently serious, then they will trigger the deportation process. And that can be against the wishes of, for instance, the EU national. However, again, representations can actually be made at that stage. And because it is not a foregone conclusion that deportation can take effect, it can be the case that if desired, representations can be made for the individual to stay within the United Kingdom, if, for instance, they want to continue working here after they've served their sentence. And another part of the sentence, the final part I wish to speak of, that really involves, again, collaboration between firms in different jurisdictions, namely here, the UK and for instance, Spain, is to do with assets that might be the subject of any sentence in the United Kingdom. So along with any sentence of either imprisonment or potentially a fine, comes with it, under the Proceeds of Crime Act, that the potential that the courts can order for assets from the individual, even a foreign national, if it's Spanish foreign national, to be subject to confiscation, whereby they have to pay up proceeds towards the crime that has been deemed to have been committed. Now, if, of course, in confiscation in the United Kingdom, it's an order against the person individually, and if they don't comply, then they may serve further prison time. So that individual may, of course, ask his solicitors, either in England and Spain, to sell and realise his assets in Spain to make sure the order is satisfied, so that he isn't subject to any further prison time. But if they are non-compliant, then the courts can impose an enforcement receiver. And in that case, it may be that if you're advising clients, they are seeking to retain the assets against the enforcement receiver who is seeking to pursue them over in Spain. My experience of enforcement receivers trying to comply with orders, say for instance, if your firm is engaged in, let's say in this instance, assisting the authorities in trying to realise the asset, it can take a great deal of time. Again, you're talking months rather than weeks in terms of trying to realise the assets. It's far more common that if an order is that it's dealt with quickly if the individual decided to sell his assets to realise the order, rather than the process whereby the court is ordering those assets be sold up and seized. But again, at all points, those who are representing both in England and Spain can assist either the individual retaining or the courts, if they're being instructed by individuals who are seeking the orders to be imposed, to try and sell up those assets abroad. So that gives you an input into some of the flashpoints that can occur for foreign nationals. And I think as we're at 12 o'clock, if I pause there, and perhaps we can have any questions, if there are any questions.
Brilliant. Thank you so much, Richard. Yeah, so thank you very much, all four of you. And we now have some time for questions from the audience. If you have any, please, as I said before, just write them in via the chat function there, or the Q&A tool as well that you can see at the bottom of your screens. So one that we've received to start us off is for Paula. And the question is, in the UK, is there something similar to the pareja de hecho that exists in Spain? Is there a registry for this as well in the UK?
No, there isn't. Here is either no regulation at all, so what is a cohabiting couple, or there is some sort of marriage, and I say marriage in between brackets because you might have heard about civil partnership. Civil partnership is not the same as pareja de hecho, is not the same as the Spanish concept of that. Civil partnership was created when same-sex marriages weren't yet accepted, and at the time, because it was a bit controversial, what the government did was, okay, we don't call it marriage, we call it civil partnership, but it was only applicable to couples of the same sex. Effectively, now, obviously, the UK allows marriage itself between same-sex couples, and they can choose whether they want to enter into a civil partnership or into a marriage, but that is only allowed to same-sex marriage. So the answer is no, we don't have the same concept.
Brilliant. Okay, thank you very much. I now have another question for Richard, okay, which is, what happens if a crime such as a corporate crime occurs in multiple jurisdictions? Where would the proceedings occur?
Thank you. the answer that it could actually occur in potential jurisdictions, it depends on the extent to which it has occurred in each jurisdiction. And it also depends on which country potentially is interested in proceeding with it. In relation to European members, that it should occur first in the context taking place, if that is something that's easy to identify. Sometimes it is, sometimes it isn't. The other thing is, though, that if a country initiated them and got a substantive way to, for instance, investigate and it's not the case that countries in multiple jurisdictions should be bringing incident. So really, in answer to that question, it should be taking place in a country where the majority of the conduct is. Also, in addition to that, it should take place been interested in, been investigating the conduct and got furthest perhaps with the investigation. What should not happen is that it's conducted at the same time in multiple jurisdictions, where the individual is tried in different countries for the same thing at the time. In England, liaison between the authorities to see who is going to conduct the I hope that answers the question.
Yeah, thank you very much, Richard. Now a question for Sophie. Okay, this one says, I'm worried about travelling now that the UK has left the EU. Can I come back in even though I haven't applied for any document to confirm my status?
Thank you very much for that one. It's quite a common question that we get from EU nationals who are concerned that they haven't applied under the old regulations that we talked about for a right of residence document or a permanent residence document, and they haven't yet applied under the EU settlement scheme, or perhaps they've applied but they haven't had the decision. And that's absolutely fine to continue travelling. There should be absolutely no difficulties at the border when re-entering the UK. I'd say that the client's concerns usually fall into the sort of two different timing groups. So if someone's already resident here and they're going to be travelling between now and the end of December, well, as I said, free movement's continuing, so I think most people feel relatively comfortable about that, and certainly there's no issue at all. But of course, from next January, free movement will have ended. And how does a border official, an immigration officer at Heathrow, judge whether the person arriving is someone who is returning, having resided in here before the cut-off date of the 31st of December, or someone who's a new arrival? And of course, they can't. And so there's really, because the deadline for making an application under the OSS is actually June 2021, really what we're going to see is no real difference at the border in that sort of 6 months grace period, as it were, from the 1st of January next year until June. Travel should not present any issues, but after the end of June 21, that's when we may start to see different approaches at the border for those coming in after that date. So certainly for the next year, nothing to be worried about.
Okay, great, thank you. Paula, there was just a bit of follow-up on, there's a bit of, oh, you've just answered that one. Okay, thank you very much.
So I
right.
just wanted to clarify that is more a question for Sophie.
Okay. All right, brilliant, no worries, I'll ask it again. Hang on one moment. Sophie, civil partnerships considerable in immigration matters, for example, to get a legal residence in the UK?
Yes, they are. So a civil partnership is treated in the same way as a marriage. So if, we have provisions under EU law for family members, and we have separate provisions under UK domestic law for the partners and spouses of what we call settled persons or British citizens. And in both terms, they are recognised in slightly different ways, but you can apply on the basis of being a civil partner.
Brilliant, sorry about that, just a couple of technical difficulties there. Okay, Right, we've got another question that's come in now. This one is also for Richard. How would a Spanish or foreign national notify the embassy that they have been arrested? And also, in addition to that, how would they go about getting bail to return to Spain pending criminal proceedings?
In terms of notifying the embassy, if you've been arrested on the street, so to speak, unexpected, then it's your right when you're station prison so then prompt and can be Spain, which is common Spanish nationals who happen to be your application to the court, who then will liaise with the Home Office and the Spanish courts to obtain. It is not necessarily a quick process. It does take, but it's lodged initially with an application in the courts for the European Supervision Order. Now, some courts have got very good systems, Isleworth, for instance, which deals with a lot of these particular issues. And in fact, I think they've set up a number of judges who are very good at dealing with these now. Others perhaps need a bit more time. But as I say, it's primarily dealt with by application to the court under various provisions issued by the directives.
Brilliant. Okay, thank you very much. Please do keep messaging in with to us with your questions if any of you have any. I've got a question now for Alvaro, which is, what happens with joint assets within a state? For example, joint bank accounts or property in England and Wales?
Okay, well, when it comes, for example, to joint accounts, it is very different to what happens in Spain. It automatically passes to the other person that the other account holder. For example, if you and, for example, your housemate or flatmate co-own, well, are joint account holders of a bank account, it will pass to the other person. If you have, if you have it with a friend, with a relative, it doesn't matter whether you are related or not. It automatically passes to the other person. A different thing is whether you will have to declare it for inheritance tax purposes. So, for example, if that bank account, you will have to declare it for inheritance tax purposes, even if it's passing to another person. So you will have to complete the balance on that account, or the share on that account in the inheritance tax returns. In relation to property, that's very interesting, because here in England there are two ways to own property when more than one person owns a property. So you can have either tenants in common, which is very similar to a Spanish system, which is when two people have a percentage or a fixed share in a property. Or then you have joint tenants, which basically both of them, shall we say, is like if they owned the 100%. So when one dies, it automatically passes to the other. Even, for example, if you put in your will, if you leave in your will that you are leaving that property to someone else, you can't, because it automatically passes to the surviving owner. If it is between husband and wife or spouses, because of the spousal exemption, it will pass to the other person and there will be no inheritance tax. There will be no need to obtain a grant of representation, just to fill in a form at the land registry. But if it's co-owned as joint tenants between two persons that are not married, then there will be inheritance tax. It will pass automatically, but you will have to declare and pay for inheritance tax over the share that has passed to the surviving owner.
Great, thank you very much. We've got another question now. I think maybe Sophie, you'll be best equipped to answer this one, although if anyone else has anything to say, that's great too. If we bring in young Spanish people to do internships in London for both Spanish and British companies for 6 months with no cost for the company, will we be able to carry on doing this without a visa or sponsor post the end of the transition period?
That's a very good question. Yes, but how is probably the question. So those who come into the UK before the cut-off date and remain here, they can carry on. But those where they're going to be newly coming for internships in future years will need to fall within the provisions for interns, of which there are some provisions that already exist, but we expect them to be evolving for the future, and it will depend a little bit on the negotiations that happen, because we may end up with some reciprocal agreements around some of these issues in the sort of ongoing negotiations with the EU. At the moment, people cannot come in as visitors and do internships. That would be unlawful. I'm talking about under UK immigration laws, non-EU nationals. So in the brave new world of the future after free movement, EU nationals will essentially be treated in the same way as non-EU nationals, and therefore they can't just come as visitors unless there is specific agreement to allow that. So they would need to fall within special internship arrangements. So at the moment we have something called Tier 5 government authorised exchange, which is specifically for interns of various different guises. It's a sponsored route, but the sponsoring organisation isn't the employer, it's an overarching body, and there are many, many, many of them. And no doubt there will be more of them in the future to accommodate these needs. But there are some sort of general ones that are for graduates, schemes like BUNAC or GTI, you may have heard of some of these. So those are options that exist now for non-EU nationals that could be used for EU nationals in the future, but I anticipate that we'll see additional provision anyway by the time we get round to this in the new year. And if I may cheekily just add a comment on the question, I think it was that Yeli had asked about civil partners, it's probably important to just add something about the position of unmarried partners. So they're not married and they're not in a civil partnership. They are recognised by the UK under EU law, and they are treated differently in UK domestic rules to how the UK interprets free movement. So with UK domestic rules, an unmarried partner must prove that they have been cohabiting with their British or settled partner for at least 2 years. In EU law, the terminology is that they're in a durable partnership, a durable relationship. Now the UK has chosen to interpret that as meaning 2 years cohabitation, which is not what EU law requires. But in order to avoid getting into sticky water with the EU, the UK does recognise that there may be circumstances where less than 2 years would be acceptable. And so, for example, if a couple have children, they're not going to, and they don't have 2 years cohabitation, they're still going to be recognised as durable partners. So far, so good. But under the current arrangements, that recognition of the partnership has to be duly attested, and that basically means recognised by the Home Office. So in terms of the practical impact of that for people benefiting from the EU settlement scheme, is they can only apply under the EU settlement scheme as an unmarried partner, family member of an EU national, if they have already had their relationship duly attested by the Home Office by having applied for a document under the old regulations. So that's a family permit or a registration document. So anyone who's in that situation, you can't just apply to the ESS straight away, that lovely simple procedure I described. You first got to get your skates on and apply under the old regime. So just to add that for the situation of unmarried partners as distinct from civil partners.
Brilliant, thank you very much. Brilliant, that's really interesting. Another question for Alvaro is, I have investments in Jersey, will my English grant be accepted?
Well, basically, there is a separate process. Guernsey is another jurisdiction, first of all. And basically what will happen is that you will need to do what is known as the resealing of the grant. So basically, once you have a UK grant, an English grant, for example, if on your death you have assets in England and Wales, and then you have that asset in Guernsey, your English grant can be resealed in Guernsey, but it will have to be done through a lawyer, a Guernsey local lawyer that will have to address that issue. However, if you don't have any assets in England and Wales, I mean, you will have to apply for a grant of representation locally in Guernsey in the ecclesiastical court. So it will be a different process with similarities, but it's a entirely separate process.
Great. Thank you very much. Okay, we've got another question here, which is for Paula, which is, you've mentioned that the 2-year separation as a grounds for divorce. Could you go into more detail on what the requirements are for this grounds of divorce?
Well, what is important for the parties to know is that the 2-year separation means when it doesn't necessarily mean physical separation. So you might be living in the same property because for whatever financial circumstances you cannot leave the property, or you both own it and you don't want to have to move. So the court, even if you have been living under the same roof, they could consider that you have been living separately as long as you don't share dinner time, do each other's laundry, obviously sleep in the same bedroom. So it's things like that, that if you have carried out completely separate lives and not as a couple, watch TV together, can also be considered as being separated. So it doesn't have to be physical separation as such.
Great, thank you very much. Okay, one more question for Richard. If a crime, for example, a corporate crime occurs in multiple jurisdictions, in this case, for example, a Spanish person may be committing this crime in the UK, would they be able to serve their sentence if they're imprisoned in Spain?
Yeah, I think I perhaps touched briefly on that during the talk, but the position is say that in relation to questions of bail, deportation come up quite a lot as well. Now, the Home Office removing people by way of deportation, they can be removed to serve the sentence in Spain, can be deported from the United Kingdom if the crime is one that's severe enough, and again, depending on how long they've spent in the United Kingdom. If they haven't been there, so for instance, we were talking of the holiday maker type scenario, and indeed they, in addition to not being here a long time, the crime is quite a severe one, then the likelihood is that that's exactly what the British government would seek to do, to deport them to Spain, and they can do that prior to the sentence ending, so they would end up back in Spain, deported, serving the sentence, so that afterwards they then wouldn't be allowed to return to the United Kingdom. In terms of voluntarily requesting to serve your sentence in other jurisdictions, that's a bit more tricky. Generally, it's very difficult for lawyers to be able to try and seek to have an individual serve, because of their own volition, a sentence in the other jurisdiction, i.e. national has been a holidaymaker, serves or was sentenced, subject to a prison sentence in the United Kingdom. It's very difficult to be able to get that individual to Spain because they want to be back in Spain to see their family. So it often occurs far more, in my experience, where the government is seeking to remove somebody from the jurisdiction than it is than somebody who wants to voluntarily go back to Spain, for instance, to serve their sentence there.
Brilliant, thank you. Right, we have one last question, which is a very pertinent one. This is for Sophie again. My business employs a lot of workers from the EU. How will we be able to secure the workers we need once EU free movement ends?
So I think probably the main answer here is that yes, you will be able to obtain those workers, and the main concern we have is around cost. So as I mentioned earlier, we have the tier 2 system and something very similar to that system will be in place, enabling employers to sponsor workers from all over the world, including EU national workers. The present requirements, as I mentioned, are likely to be reduced, so that whereas currently the scheme only allows people in graduate level professional roles to qualify, though they will be a much reduced sort of A-level standard will be the minimum skill standard. The concern, I think from a practical perspective, is the cost and the headache factor for employers, because under the current scheme and under the proposed new scheme, employers will have to first apply for a sponsor license. So if it's an organisation that doesn't already have a sponsor license, you have the cost and inconvenience of having to make that application in the first place. There are then very onerous duties to maintain your sponsor license, and the reporting and record keeping duties that you will be subject to as a sponsor. So although it's all very much achievable, it's taking on that additional cost and expense. But in addition, for each migrant worker that's being sponsored, there are a cohort of charges that the Home Office applies. So there are, there's the cost for applying for the sponsor license if you don't already have one. There's the cost for assigning a certificate of sponsorship to each worker. There is the filing fee for each worker's individual entry clearance or leave to remain application. There is the something called the immigration health surcharge that is about to go up in October. And there is also a skills charge. So just to illustrate, if you are hiring a worker and you're going to sponsor them for the typical 5-year period, and they happen to have the typical spouse, partner, and 2 children, your upfront costs, without any lawyers involved, to the Home Office are going to be about £20,000 for that worker. Now, obviously, there's lots of variables, and it's different depending on the period, and there are certain exemptions for charities or small sponsors. But generally, our concern is that the way to control the numbers of migrants is going to move increasingly towards pricing businesses out of the market, so that only businesses with the deepest pockets will actually be able to afford it. And so that's an area where we're really encouraging people to try to challenge the policy. And obviously, COVID experience has been horrendous on so many levels, but the positives, and there are a few to be drawn from it, but one of the positives is the value being given to key workers, and the understanding that we now have gained in the world and in government, that many workers who are not well paid are absolutely critical to how our country functions, and hopefully that will also play into these arguments around cost for businesses and individual migrants. We shall see.
Great. Sophie, we've just got another question that's come in for you quickly, which is, in the UK, foreign nationals can be expulsed from the UK for criminal matters. Is there somewhere that people can read about this, for example, a book or an act or something like that? Do you have any advice?
Yes, I mean, the Home Office website is quite good for guidance that makes it more digestible, and I can provide links to that. The provisions are different for EU law compared to under UK law, and for EU nationals, the date of the activity, the date of the criminal activity will determine which applies, because they will become subject in future to UK law. To express it in the most simplistic terms, it is quite difficult to exclude an EU national from the UK for criminal activity unless it's very serious, whereas it's very easy to exclude an EU national, a non-EU national from the UK for criminal activity and for things that just fall under character, conduct and association and aren't even a criminal activity at all. So there's separate, very detailed guidance that the Home Office sets out about how it interprets the different provisions, and so I can provide the links for that.
Brilliant. Thank you so much, Sophie. Right, thank you very much. We've had lots of questions, and just to close now, we've had Irene has made a comment, but it's very relevant. It's relevant to immigration. So Sophie, to your area of work. She's just written in there, a reminder that settled status is linked to the passport number. Spanish passport numbers change, so if your passport expires soon, it will be advisable to renew your passport before applying for settled status. I found myself in a situation where my settled status is linked to a passport that has now expired. I sent my new passport in for them to update the status back in January, but they have not updated it yet. make sure you renew your passport and then only apply for settled status. I don't know if you have anything to add to that.
I do, and that's a really important practical point, and thank you for raising that, Yeli. It is a real problem, and sort of underscores some of the nonsense of the sort of PR aspect of the government saying, this is so easy. When you're applying under the EU settlement scheme, it is really beneficial that you don't have to give up your passport. All the passport data is magically taken from your passport through the app to the Home Office. You never have to be without your passport. Some people aren't eligible to use that app, but they can attend a biometric centre instead, where their passport data is verified. So again, they do not have to relinquish their passport. And then when they change their passport, suddenly they're being asked to post their passport into the Home Office and be without it for a period, and whatever that period may be, it's an unacceptable period. So it's a really important practical point, and it's something that we, and indeed many other lawyers, have been lobbying the Home Office about for quite some time, to get them to bring in systems so that the new passport data can equally be uploaded through the app and so on. So we are sort of hopeful that they will change that, but yes, at the moment, it's an issue.
Cool, thank you, Sophie. That's a really, it's a very practical point, and thank you, Irene, for writing in with your experience. Brilliant. Well, that's all we've had time for today, but thank you so much for writing your questions and for joining us this morning, and a special huge thanks to Sophie, Paula, Richard and Alvaro for sharing with us your great insight and expertise in these different areas. I hope that everyone who's joined us has found it useful, certainly as useful as we have. So yeah, and thank you very much, everyone. Please, everyone, keep an eye on the Spanish Chamber of Commerce's website. We organise a lot of other online events, which we'd be delighted if you would join us for. And yeah, this event is going to be kept up on our YouTube channel, so if you'd like to share it with any of your colleagues or contacts who you think it would be useful for, please do that. I'd also like to note that later this afternoon, I will send around a feedback survey about it, and in that email, I will include the contact information for Sophie, Richard, Paula and Alvaro. So if you would like to contact them about the services of their firms, or if you have any further questions, you can do so. All right, thank you so much, guys. All the best. Bye-bye.